Apartment Building Accidents in New York, Tenant Rights Against Negligent Landlords, attorney Andrew M. Stengel. So, when a landlord cuts corners on maintenance, ignores building violations, or fails to address known hazards, the consequences can be devastating. Broken bones, spinal injuries, and traumatic brain injuries are among the most serious outcomes New York tenants and visitors face every year. Under New York law, building owners owe a legal duty of care to every person lawfully on their premises. And that duty does not disappear because they hired someone else to handle repairs. If an apartment building accident injured you anywhere in New York, you may have a strong premises liability lawsuit against the building's owner. This post explains your rights, what evidence matters, and what to do immediately after an accident. What New York law requires of landlords and building owners. New York landlords owe a duty of reasonable care to tenants, guests, and any person lawfully on the premises. That duty covers every common area under the landlord's control: lobbies, hallways, stairwells, elevators, laundry rooms, parking garages, rooftop terraces, and building entrances. Landlords must conduct regular inspections and promptly repair any hazard identified or reported to them. Critically, this duty is non-delegable under New York law. So even when a landlord hires a superintendent, property management company, or maintenance contractor, the owner cannot escape legal responsibility for unsafe conditions. A building owner cannot hide behind the argument that someone else handled maintenance. If a dangerous condition existed and someone was hurt, the owner is responsible. The New York City Building Code and the Multiple Dwelling Law establish specific requirements for each type of common area. Violating those requirements can establish liability directly. Evidence of that violation comes from Department of Buildings records, prior tenant complaints, and the landlord's own maintenance logs. Common building hazards that lead to premises. Liability lawsuits in New York. Building accident lawsuits in New York arise from a wide range of conditions. For example, broken lobby doors and defective vestibule locks create unauthorized access and expose tenants to criminal attack. Worn steps, loose railings, and poor stairwell lighting cause serious falls every year across the 5 boroughs. Elevator malfunctions, including sudden drops, doors closing on passengers, and leveling failures, injure residents throughout New York. Inadequate hallway lighting enables both accidental falls and criminal attacks in buildings that neglect their obligations. Roof and terrace hazards, defective railings, deteriorating parapets, and unsecured roof access expose residents and visitors to catastrophic injuries. Each of these conditions represents a failure to meet the obligations the New York City Building Code and Multiple Dwelling Law impose on building owners. Thus, when a landlord knows about a hazard and does nothing, that failure becomes powerful evidence at trial. How DOB and HPD violations build your case against a landlord. The New York City Department of Buildings maintains publicly searchable records of all violations issued against buildings throughout New York. Outstanding DOB violations are powerful evidence in premises liability lawsuits. They establish that the landlord received notice of a dangerous condition and failed to act, a pattern of neglect courts take seriously when determining liability. Additionally, records from the New York City Department of Housing Preservation and Development document housing maintenance code violations, including broken locks, defective stairs, and inadequate lighting. These records frequently appear alongside DOB violations in building accident cases. Together, DOB and HPD records can establish 2 critical elements. First, the landlord had actual notice of the condition. Second, the landlord repeatedly failed to fix it. Both elements strengthen a premises liability lawsuit against a New York building owner, and your attorney can obtain these records before discovery even begins. What to do after a building accident in New York City. The steps you take immediately after an accident can significantly affect the outcome of a lawsuit. Seek medical attention right away. Your health comes first, and a medical record links your injuries to the accident. Report the incident in writing to building management the same day if possible. Photograph the hazard and your injuries before anything is repaired or altered. Collect witness contact information and preserve any communications in which you or other tenants previously reported the condition. Texts, emails, or letters. Do not give a recorded statement to the landlord's insurer before speaking with an attorney. New York's statute of limitations for premises liability lawsuits is generally 3 years from the accident date. However, if the building is government owned, a notice of claim must be filed within 90 days. Missing that deadline permanently bars the lawsuit. A successful premises liability lawsuit may recover medical expenses, lost wages, pain and suffering, scarring, and punitive damages in cases involving egregious landlord conduct. Injured in a New York building? Contact us now. Landlords and their insurers move quickly to minimize liability after a building accident. The law firm of Andrew M. Stengel, PC, moves faster. Our firm represents tenants and visitors injured in apartment building accidents throughout New York, investigating thoroughly, identifying all liable parties, and building the strongest possible case from day one. All premises liability matters are handled on a contingency fee basis, so you pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.